Okay, I think we're up to episode number 6, and I'll read this first paragraph. Whereas Paul Johnson has also posted and commented several times on Facebook, stating, among many other things, that the district members are intentionally doing several things illegally concerning beekeeping, that there has been an illegal denial of numerous open space applications. Maybe I'll just read all three of these and then we'll talk about them. Whereas the board again finds that Paul Johnson's complaints are better phrased as complaints that he disagrees with district decisions that affect his own property. They should not be characterized as claims that the district acted illegally or outside its authority, although Paul Johnson attempts to characterize them as such. Whereas Paul Johnson has posted on Facebook stating Bastrop Central Appraisal District is breaking the law by enforcing production requirements that are not in the Texas Property Tax Code, and further posted a video on February 24, 2025, titled Appraisal District's Illegal Production Requirements. In this YouTube video, Paul Johnson claims that the district has illegal production requirements because he believes that the district is not allowing the keeping of his horses used for polocrosse to qualify for open space valuation. Okay, let's talk about these things. I did comment several times on Facebook that meant that the appraisal districts is doing intentionally doing several things illegally concerning beekeeping. And one of those we've talked about is their setting the productivity value by using false information. Here's the way they set it: using lease rates, which they're required to use. And I didn't think those lease rates existed, so I made a public information request, number 4, for the leases, the data that they use to come up with those lease rates. And they replied, they do not exist. Specified documents subject to the request do not exist. So they just made those up. There were no lease rates that they're required to use, but they posted them on their deal, which that is intentionally doing several things illegal concerning beekeeping. Well, in addition to that, regarding beekeeping, the they set the degree of intensity too high for beekeeping, way too high, far above the level that they're supposed to set it, generally accepted in the area. And it has to be generally accepted in the area for non-migratory beekeeping operations that are on tracts of land between 5 and 20 acres, because that's what the requirements are. So they need to set the degree of intensity for non-migratory beekeeping operations, beehives that are on one place, on one piece of property all year. And they didn't do that. So they end up setting the degree of intensity way higher than is typical, than is generally accepted in the area for beekeeping operations that would qualify. Then it says, there's also been an illegal denial of numerous open space applications. Well, I believe that too, that the appraisal district has a breeding requirement. I'll show you their breeding requirement. This is their guidelines, under non-qualifying activities, to keep or use horses in some manner that is not incidental to breeding or raising horses. So they're saying if it's not incidental to breeding, it's a non-qualifying activity. There's nothing about breeding in the property tax code, but they do have this breeding requirement in their in their ag manual, and they also have a production requirement under pasture. Here they said you have to achieve a minimum standard of production to qualify for agricultural use. Here, minimum standard of production for pasture. So they have a production requirement and they have a breeding requirement that are not in the law. And here is a property tax court of appeals case that says agency rules, and these guidelines are agency rules. Agency rules, of course, may not impose additional burdens, conditions, or restrictions in excess of or inconsistent with the statutory provisions. So anything that they have that in their rules that is a burden, condition, or restriction that is not in the law, they may not impose them. That's what this case law says. That says any rules, but they specifically have said they cannot have a production requirement. That's in this. It is a Kerr County versus Stacy case. In that case, it says the primary question before this court is whether property which is leased for the sole purpose of grazing horses, which are used only for recreational purposes, qualifies as open space land. So that's the question the court was deciding. And they determined that simply because the horses in the instant case are used for recreational purposes does not indicate that the land itself is being used for recreational purposes. So it's not what the horses are used for that makes a difference. It's what the land is used for. And the law says keeping horses is an agricultural use, a qualifying agricultural use. And here's guidance from the comptroller's office. Somebody wrote in, said, in reading the 1990 manual, it states that horses do not count as an agricultural exemption if they are not bred. So that was the question they're asking. And here's the answer that they were given. And this is from Deborah Cartwright. And at the time, she was the director of the Property Tax Assistance Division at the Comptroller's Office, which is the highest office you can hold that has in the Comptroller's Office that deals with property tax cases. Anyhow, so it comes directly from the director, and it says, please note that a 1989 court decision overturned that provision in the manual. So he was in the manual, it says they have to have a breeding operation, but she says this Stacy case, and that's the case here they actually name it, but that's the case I just showed. And then in the 1990 manual, it was still there, and she puts in parentheses, the manual was adopted in 1988 and amended in 1990. And so it did not address the 1989 case. So she's stating here that they made a mistake by keeping that breeding requirement in because it had just been overturned by that court decision in Kerr versus Stacy. And as it turns out, they didn't change the appraisal manual again from 1990 until 2017. So for 27 years, that incorrect ruling was in their comptroller's manual. Well, the comptroller's manual is also agency rules. So the comptroller's manual cannot have any burdens, conditions, or restrictions that aren't in the law. And this would be one of them. But this specifically overturned that rule that they had in their comptroller's manual about you had to have a breeding operation. And as you remember, you can see that the Bastrop Central Appraisal District still has a breeding operation in their manual. And then it says that court held that property used for grazing horses was open space land, even if no agricultural product was produced, and even if the horses were only used for recreation. You saw that the Bastrop Central Appraisal District also has a production requirement. But this said there is no production requirement in the law, and the production requirement, so it would be in excess of statutory provisions. But this production requirement was specifically overturned in this Kerr versus Stacy case. And then the that was the illegal denial of numerous operations for open space appraisal that I was talking about, and you can see they are illegal. They have requirements for well, I haven't even named all of them. They have several, but they have a production requirement that you saw and a breeding operation requirement that you saw that they're not allowed to have. So those are illegal, and they're illegally denying numerous open space appraisals. So I put that in there, and I stand by that 100% because it's absolutely true. And then they claim that my complaints are better phrased as complaints that he disagrees with their district's decision that affect my own property. They should not be characterized as claims that the district acted illegally or outside its authority, although Paul Johnson attempts to characterize them as such. Well, I never claimed what they're doing is wrong because how they any decision they made on my own property. I have only said it's wrong because the law says it's wrong. And I showed you exactly where the law says it's wrong. But they just make that particular statement without any support. It's unsupported, it's conclusory, and they don't cite any facts or examples showing that my complaints concern my own property or that I merely disagreed with the decision. Every concern I have raised has been directed at the district policies and practices that affect all property owners and have been supported by documentation and statutory authority by the law. So then they say I have Facebook postings stating Bastrop Central Appraisal District is breaking the law by enforcing production requirements that are not in the property tax code. Well, I just showed you they have production requirements, they are enforcing them, and they are not in the property tax code. And I showed you the law that says they cannot enforce rules that are not in the property tax code. And I showed you they cannot enforce production requirements. and further posted a video on February 24, 25 titled Appraisal District's Illegal Production Requirements. In this YouTube video, Paul Johnson claims that the district has illegal production requirements. Well, I did claim that, and I do claim that. And I've showed you exactly where the law says that those production requirements are illegal. And the comptroller has said, no, the production requirements, the breeding operation, that was overturned by Kerr versus Stacy. The director of the comptroller of the Property Tax Assistant Division of the Comptroller's Office said that, and he put that out. She put that out to all of let me get this is the it's called they call it an email blast, I think. Anyhow, it went to all chief appraisers and tax collectors, and they went about putting out the definition, the livestock definition, maybe because their comptroller's book, their manual, had that mistake in it for so many years. This came out in 2013, I think. And so it had been in there already since 1990. So it had already been in there 23 years. And they'd probably put things out this more recent, sooner after they made them a change and saw there's a mistake. They probably put these out. When I made this public information request, they only went back 3 years with it, saving these emails and stuff. So I didn't have access to any of the other ones that they probably had to do it quite regularly. When the 1990 manual first came out, they realized it's a mistake. But anyhow, they put it out again in 2013. And it says in the definition of livestock, the livestock only must be raised or kept on the property. No other requirements exist in the statute or comptroller rule regarding the use of the livestock. Well, that's what I've always said. And there is you've seen the law, you've seen the comptroller's advice about all that stuff. And then they said, in this YouTube video, Paul Johnson claims the district has illegal production requirements because he believes that the district is not allowing the keeping of his horses used for polocross to qualify for open space valuation. In my YouTubes, I don't think I ever mentioned anything about my own horses or about polocross or the use of my horses for polocross. But here they brought that up, and I don't even know. Well, they did. They got it from somewhere other than my YouTube videos, because I don't think I brought up that my horses were used for polocross. However, there is a court case that did mention me using my horses for polocross. So when the appraisal district filed on me for being a vexatious litigant, one of the things that they had to prove, of course, is that I had 5 litigations that have already been finally determined against me. And of course, that didn't happen, but they were still using this wrong counting method. But when it got appealed to the Court of Appeals, they overturned the vexatious ruling, not on the over 5 litigations finally determined against me, but on this other thing that they have to prove when they have vexatious litigant is that I would have no reasonable expectation of prevailing in the underlying property tax suit. So this was for my 2022 property tax case for the open for because they denied me an open space appraisal. And for 10 years, they had been denying me based on I didn't have a breeding operation. They claimed I was using my horses for recreation, so that made the land not qualifying for open space appraisal. Here's what the Court of Appeals said about that, and they're talking about the conditions on my own property. And they're referring to evidence that had just been used in the 2019 case that the appraisal district had used in the 2019 case that went to a jury trial that was found against me. And they say in here, they actually admitted the very same evidence that they had presented in the 2019 jury trial to prove that the use of my land was recreational. So here's what the court said. At the hearing on its motion, the appraisal district argued that it was admitting portions of the 2019 trial testimony, the Facebook posts, and photos of people playing polocrosse on the subject property going back many years to demonstrate that the principal use of Johnson's property from 2011 to 2019 has been to train horses for polocrosse, and which they claim is not an agricultural use, but a recreational use. So this court actually mentions the use of my horses being trained for polocrosse. I don't think I mentioned that in my videos, but they mentioned that in the resolution that they passed. But here's what the court says. The appraisal district did not cite any authority supporting its assertion that keeping, raising, and training horses for polocrosse or sale or feeding them on fodder is not an agricultural use of land on which the horses are kept. So they're saying the same thing that was said in the Stacy case, same thing that was said by the comptroller's manual, that it is not the use of the horses that matters, it's the use of the land, and the use of the land is for keeping horses. And the comptroller told you there are no other restrictions in the law or in the comptroller's manual. And this Court of Opinions found that I was keeping horses on my property. And whatever he said, whatever the appraisal district said was happening with the horses that was recreational did not prevent the land from qualifying for open space for where the horses are kept. Same thing that was said in the Stacy case. The Stacy case, they said, even though the horses are only used for recreational purposes, the land qualifies. For the land that the horses are kept on qualifies. Okay, we're going to end that there, and there will be another one. So stand by or tune back in.